Okay, Chair Moore,
Present.
Commissioner Compost,
Here.
Commissioner Dolan,
Here.
Commissioner Gary,
Mike is present.
okay, Commissioner Ruiz, Commissioner Ramirez. Okay,
Did Commissioner Aguirre get a phone call?
He did. Yeah, I talked to him this afternoon.
Okay,
So I'm going to send him an email right now.
all right. And Commissioner Ruiz, does he have an excused absence?
Not as far as I understand.
Okay, any reason why he may not be here?
Not that I know of.
And was he given a phone call that the meeting was not 6:30, but it was 5:30?
Yeah, I talked to him yesterday
Okay,
actually about
okay.
it.
Okay, so we have no minutes to discuss. We will have June and July for our August meeting, so we'll go over those minutes then. If you want to reflect back before that meeting next month, just to go over the notes, just in case. Our active agenda today is a workshop with YVCOG and the planning manager, Byron, is it Gums?
Yes.
Gums, thank you for being here. We're anxious to hear what you have to teach us and ready and willing to learn. I don't know if Trevor's still.
Yeah, I will share my screen in
Okay.
just a second here. Oops.
Is there training online that people can go online and go through this?
There's a wealth of resources that are out there. Most of the information I pulled for this presentation I got from MRSC, it's Municipal Research Service Center,
Mhm.
and it's available to local governments, county governments, planning commissioners, so forth. And they have discussions and information on a wide range of topics, everything from subdivisions to fairness doctrine to annexation, you name it.
Mhm.
It's covered. It's a nonprofit, but it's a bunch of legal services, a lot of attorneys, and so
Oh,
forth.
okay.
People that are involved with planning that provide responses to questions that cities may have or commissioners may have.
Okay.
The Washington State Department of Commerce also has some trainings. There's a short course on planning that they provide. It's about a 4-hour training, but it covers the breadth of what planning is in the state of Washington. Growth Management Act, code cities, non-code cities, GMA participating, partially planning communities, all sorts of things. It's good bedtime reading.
Yeah, right.
Okay, so I'll just jump into it. The intent of this is just kind of a broad overview of the roles that a planning commission has for a community. Essentially, a planning commission is comprised of members of the community, and you are reviewing different planning related projects from that level. I'll go through the slides here. I know Trevor printed off copies for you. I print them off as full page. Some of the text may be easier to read your pages. But essentially, if you want to go to the next slide. Planning Commission, it's established under Washington state law. There's 2 RCWs, 35 and 35A. They essentially say the same thing, that it's intended to be members of the public, citizens, as I mentioned, that provide a level of review to the community. And there's typically 2 distinct functions that a planning commission has, and I have them on the next slide. So you're reviewing, so there's reviewing of comprehensive plans and development regulations. So that's your zoning ordinance, your subdivision ordinance, critical areas, shoreline master program. I don't know if you have one of those for Sunnyside.
No shoreline. And just an FYI, it looks like Mr. Aguirre is on on Zoom now, so looks like he's in attendance.
Hi, Mike. It's not Mike, is it? No.
Mhm.
Hello, I'm here.
So that's one thing, and then the other is the review of development proposals. Then with development proposals, it can be one of two things, either where you're making a recommendation to city council or you are making the decision. And when you're making those decisions, it'll be at a hearing, and there's two types of hearings. There's a legislative hearing and a quasi judicial hearing. With legislative is when you are looking at a project that impacts the entire community, and it's kind of for the broader good or the broader impact of that plan on the community, where quasi judicial is going to be something that's very site specific, and the importance is more to a subset of your population rather than the entire community. The main difference there, I mean, there's a number of differences, but the main difference is going to be the intent of what that hearing is. With legislative things, it's more policy driven. And then with quasi judicial, it's more the application of those policies. So that's where it's reflected in your development standards and things like that. Legislative is really an open forum where people are giving you their feedback, their opinions on the way that a policy should be going. Where quasi judicial is more facts relating to the case, how it may impact them. So it may be something that is going to generate more traffic or noise, or something that could disrupt their community. Let's see, so legislative hearings. So this is where you're going to be making a recommendation to city council. The main concern is providing an opportunity for all attending members of the public to speak if they so desire. So with this, there's typically, depending on the number of people in your audience, you may want to limit time. So I've been in front of other councils and commissions where they may limit speaking time to 3 minutes or 5 minutes or something like that, if you know that there's going to be a lot of public comment, just to keep things orderly. Written comments are usually accepted up to and at the hearing. And then probably want ground rules for conduct of the hearing. I'll get into that a little bit further at the end of the packet that I gave you. There's some examples from other communities that have had bylaws or rules of process and procedure, as well as there's typically a kind of a guide sheet on how the chairperson would run the hearing. So it's kind of a bulleted list of things to go through and make sure that you're following the right procedure, which with legislative hearings is less important than quasi judicial. And I'll get to that in a minute. With legislative hearings, public notice needs to be sent out for those. You have to follow the Open Public Meetings Act. Making sure that you properly advertise that the meeting's taking place at a certain place and a certain time, and gets posted in the newspaper, typically, oftentimes in City Hall. It all depends on your regulations. For example, Mabton has the City Hall newspaper. Then it also has places where the public regularly convene. So it could be something like a grocery store or your library or something like that, just so you're making sure that there's adequate notice to the community to have their participation in the process. Appearance of fairness doctrine does not apply to legislative hearings. This is something that catches a lot of people by surprise. And that's because it's policy driven, right? So a lot of times you're representing a set of the community. So the idea is to get feedback on what the community is, and it's where you have those conversations with the public and you engage with the public on how they're wanting these policies to the direction they want to go in. And then your recommendation is then made through a resolution. I'm sure all of you have probably seen this already with some of the work that you've been doing. The quasi judicial hearings, this is where you'd either be making a recommendation for city council or a final decision. This is mainly where you are going to be making the decision on a specific project. So, and I'd have to look through your table to see what sort of things would come in front of you as far as an open record hearing, but maybe like a preliminary plat for a big subdivision would come through the planning commission before going in front of city council for final approval. And you really need to make sure that due process is being met, because when somebody appeals one of these decisions, it'll be based on either a procedural error or a substantive error. So a procedural error is the easiest thing to make a mistake on. So for example, a person who should have received a mailing or a mailer saying that there was a hearing, you notice within 300 feet of the parcel boundary. If you didn't notify somebody, then you made a procedural error. And if they appeal, they could win the appeal based on a simple error like that. So you really need to make sure that that procedural process and due process is being met. So there's notice to neighbors, special parties of interest. So the Accommodation, Department of Health, Department of Ecology, things like that. You need to make sure that you're ticking all of those boxes. And the Parents of Fairness Doctrine does apply. Yes, sir.
Are you saying that it's the responsibility of the planning commission to make sure that happens, or is it?
It would be staff,
Okay,
but you would need to, so you're going to be reviewing the record as part of the planning commission. So it's kind of, it's something that you're making sure that the record's complete because you're making your decision based on that record. So I'm not saying that the planning commission individually is responsible, but it's part of the process for reviewing a quasi judicial proposal.
So I've got a question. We've had instances in the past, many actually, where people say they didn't get notification of something coming up for a hearing. Do other I'm Trevor could probably answer this. Do other cities use a certified mail where they have to sign for it? Or is that over and above?
That's typically over and above. So what the common practice that I've encountered is, and we have it outlined, and that's actually, I'm staring at it right here on our screen. It's 1903-030, notice of public hearing. So every city typically has a section that tells you, it outlines specifically what we do. Typically it's not certified mail. Certified mail, it's the cost of applications would go up quite a bit if we did something like that. But typically what is required of most cities is that we send out a letter that has, and I'll just go down the list here, has the name of and addresses of the applicant, description of the property, time and date and place of the hearing, description of the property and its location and a vicinity map, a nature of the proposed development, a statement that all interested persons may appear, section of the code that's pertinent, information that may be examined, and how written comments can find me or city staff, a local government representative to contact, that a copy of the application and all documents and evidence relied upon by the applicant and applicable criteria are available for inspection at no cost and will be provided at the city's cost. And that a copy of the staff report will be available for inspection at no cost at least 7 days prior to the hearing, and copies will be provided at no cost. So that's what we do. And that's typically, so what I've seen cities do, and this is one of my practice, is I'll outline all those items in a single sheet with the vicinity map attached to the back of it, with a URL where they can go click on the city's website, get to it, or if they want to stop in the city hall, I'll provide them with a copy of the application. Because sending out applications too, if you're sending out subdivisions or whatever, it adds a lot of cost to the application overall.
Oftentimes the requirement is first class mail to
Mhm.
property owners of record according to the Yakima County Assessor's Office, because a lot of times if it's a rental, it doesn't go to the person that's living there.
Yeah,
So your address may be Arizona or Wisconsin or something
Yeah.
like that. And it will go to that person rather than the inhabitant of it. Same thing with trailer parks. Mobile home communities, things like that. It has one address, one owner, and it doesn't necessarily go to all of the different spaces within that development.
Yeah.
I've run into that before, but there oftentimes is questions to, well, 300 feet isn't very much. Why isn't it a half a mile or a mile or something like that? And I don't necessarily have the answer to why 300 feet was chosen, but it's important that it's consistent with that 300 feet. If you go above and beyond, there's opportunity for you to be appealed, saying that you're not following your process.
Mhm.
There's also typically a legal notice that goes into the newspaper, and people of like word of mouth, of course, will spread as well.
Yeah.
And there's being a public comment, the community is allowed to provide comments even if they didn't get that direct notice.
Mhm.
But for first class mail to owners of record are
Yeah.
typically what happens with mailings.
There's also the yellow signs. The yellow sign is a form of notice. There's a phone number on there that can give us a call.
Yeah.
So,
So with the quasi judicial hearings, it's based on the record or the facts and evidence. So that's where we usually have a comment period. Oftentimes it's 14 days. If there are comments that are received after that, it's really up to the director whether or not that will be considered. It kind of becomes a gray area because procedurally it shouldn't be reflected. And what I've done in the past is we'll provide something saying that this comment was received outside of the comment period. However, this is what that comment was, because with an open record hearing, you can accept new evidence at that hearing. It's just that after that hearing's ended is when that record will close and things can't be taken in or considered after that. Because when city council goes to review your recommendation, it's typically going to be a closed record hearing, so they can't accept any new evidence, any new testimony at their hearing. They have to rely on the record that's been created and provided to the planning commission, and that was created from the planning commission with your open record hearing. So you would open the hearing. There's typically a order of operations, if you will, where staff would present their staff report. And then there's opportunities for the proponent to argue in favor of approving the proposal. The opponents can get up and then argue against it. Planning commission would then ask for any sort of clarifications that they may have or want or need. And then let's see, then that typically gets directed to staff. And then from there, the hearing would be closed once there's no more comment or anything. Oh, and of course, public comments part of that. After the hearing's closed, the planning commission would then have a conversation and deliberate, depending on how complicated, how complex the case is. You may want to postpone making a decision. If there was a lot of testimony, if there's a lot of new evidence, it's best to sit and digest that information before making a decision. Otherwise, if it's something that's straightforward, then you could, of course, make your decision. It's really up to the will of the planning commission how they would like to do that. And once again, decisions made through that resolution. And then the next slides go into a little more detail about what an appearance of fairness is. It's based on RCW And it's a rule of law that requires government decision makers to conduct non-court hearings and proceedings in a way that is fair and unbiased in both appearance and fact. So the two main requirements, procedurally fair, so everybody is given equal opportunity. That's why there's mailings, there's legal notices, there's posting of the property, and they need to be conducted by impartial decision makers. And typically there's a series of questions that are asked. I'll read them. But they're written in here, and then some of the examples I have, they're in that packet as well. So the questions, if there any interest in the property or application, or if they own property within a certain distance of the property subject to the application, if they stand to gain or lose any financial benefit as a result of the outcome of the hearing, whether they can hear and consider the application in a fair and objective manner, if they have engaged in any ex parte communications with either proponents or opponents of the application, and if so, ask them to place on the record the substance of any such communication so that interested parties have the opportunity at the hearing to rebut the communications. An example of that may be like, say you're at Varietal and somebody that's proposing a subdivision recognizes you and wants to have a conversation about it. You would disclose that I was Varietal and this proponent approached me and asked if I had any concerns or if I wanted to have a conversation about it, and you would disclose any sort of material subject that conversation that you had at that time with the proponent.
And just an FYI, I'll make a kind of a cheat sheet for everybody as we go forward here. But in your experience, does it make sense to read this as we get into the agenda, when we enter into like a public hearing section of it, just jump off with the appearance of fairness questions?
Yes, and if we jump to the little packet of things, one of them is the City of Shoreline's Planning Commission's rules and procedures, and I've been having conversations with Trevor, and he has a copy of something similar that he's going through. But the next page or pages really are public hearing script guides. So one's directly from MRSC and is very generic. Then there's a couple of examples from other cities. One of them is the city of Camas, and the other one, I believe, is the city of Pullman. And they have it set up by quasi judicial and legislative hearings and what sort of things that you need to say in the process. So it really helps you. And I know so with YB-COG, we provide planning services to Grandview and Granger and Wapato and Union Gap and Tieton and others that I'm forgetting. A lot of them do have these script guidelines that they'll read prior to a public hearing, whether it's legislative or quasi judicial. And it just really helps with that process, because you're not going to miss anything. You know that you're not going to accidentally forget to ask the proponent to argue their case, those sorts of things. And I've been in meetings where it was in the city of Grandview, and a developer wanted to change the comp plan, and the city did not want to approve the proposed changes, and the proponent came back and was arguing that they didn't have appearance of fairness. They felt like the city council decided they didn't want these changes. They were essentially removing minimum lot sizes that were in the comprehensive plan, and had to be explained to them that appearance of fairness does not apply to a legislative decision, because it is a political decision. It's not based on the facts at hand. So having the script guide really helped with that, because it allowed them to say their piece and argue what they were going to argue, and they couldn't argue that their due process was violated. So they were trying to say that appearance of fairness was violated, but that argument didn't hold water and so forth. So having a script guide is something that I highly recommend that you have, and I know Trevor is working on it.
Yeah, we'll do that moving forward. Absolutely. Mhm.
And then the last question is, if there is any sort of ex parte contact, or if there is some sort of appearance that fairness isn't being met, the public can, or the proponent or whomever can explain why they feel as though it's not a fair hearing. One of the things that I was looking at in the RCWs, I didn't include it on here because it kind of starts to get into the what ifs. But if there is an appearance of fairness issue where somebody shouldn't be involved in the decision, it needs to be mentioned immediately, because if it goes past that and a decision is made, that fact that the appearance of fairness wasn't met can't be used in an appeal of the decision. So it needs to be something that's addressed right then and there. Ex parte contact is allowed for legislative decisions as part of that appearance of fairness, is not allowed for quasi judicial, just because it's supposed to be based purely on the record that's in front of you, and opinions aren't supposed to sway the decision. You're looking at what the development regulations are, what the standards are, and whether or not that proposal meets those standards or has the appropriate conditions to mitigate impacts that don't meet those standards. Let's see. There is an exception to quasi judicial, and I kind of got into a little bit. The exception is if you put it on the record. So that varietal example, if you include that in the record during the hearing, if you say, yes, I did have this conversation with the applicant, and this is what that conversation was about. And then, you basically give the opportunity for the applicant to correct that if they want to, or somebody else to speak to the that conversation that took place. And then the next sections that I have are just kind of how the Sunnyside Planning Commission is organized. Municipal Code 2.50.100. And I'm sure you're familiar with all of these, but I just wanted to have them in the presentation in case there were members of the public, they could kind of see how the Planning Commission came to be. Governing law, organized under 35A.63. Membership, 7 members, 4 are within the city or UGA, and 3 members are within the school district. Meetings, it sets up, the next slide goes to meetings. Second Tuesday of the month at 5:30. What happens if you can't meet then, or if it's holiday? Duties and responsibilities. Considering amendments, modifications, or alterations to comp plan, conduct hearings as specified by law, hear, review, and recommend proposed annexations and other planning functions as required by city council and state law. And then the next couple of slides just kind of go off of the tables in Title 1901. So you're the advisory body for city council for comp plan amendments, development regulations, zoning text amendments, annexations, and zoning map amendments, and plan unit developments. And then you are the hearing body on quasi judicial hearings for preliminary plats, plat vacations and alterations, and then major amendments to plan unit developments. There's also PRDs, which I'm assuming is planned residential developments, but I only saw it in that table and nowhere else in your code.
Yeah, I think it's a kind of a hangover thing that needs to be cleaned up.
So preliminary plats are long plats, so you have short plats, which are administrative in nature, which Trevor just handles those. And then the long plats are the big subdivisions greater than 9 lots.
Mhm.
That's when there's SEPA and all sorts of things. So you're looking to make sure that the roads are, all the development standards, roads are the right width, water, sewer. If you have open space dedication, safe walking routes to schools, things like that.
We're at 9, excuse me.
Yeah, so short plat goes up to 9, 10 and more is a long plat. Mhm.
I was told it was 6.
That was 9.
So for a long time, it was 4.
Yeah.
And the state changed it a number of years ago to be able to go up to 9 to basically to facilitate urban development. It's a lower level of review, so it doesn't require all the open record hearings and closed record hearings and so forth.
And they also changed it so that the initial hearing for a long plat, they changed it so that the initial hearing is heard by the planning commission. And then the recommendation goes to city council. They used to make it so that the final plat, when it came in, would also have to go back to city council for review, but the state also changed it like 3 or 4 years, maybe 5 years ago. So that final plat doesn't have to go back to city council because it's already been reviewed and approved by them. It just needs the administrative sign-offs from public works and so on.
If there are changes.
If there are changes, yeah.
Your process still has it going in front of council for approval, though.
Yes, it does. Yes.
So that's something that could be changed, but that change would come in front of you.
So talk with Shane.
Yeah, we can, there's ways to expedite things and or update things to make them a little more streamlined and cleaner.
Yeah, and then the last little slide there is, excuse me. You can adopt rules of procedure. So that's kind of that city of Shoreline stuff. The example I gave Trevor was from the city of Toppenish. So you essentially create this and make sure it's what you want, but the city council adopts it.
Mhm.
Then I gave the example of Shoreline, of course, and kind of went through those for you. So long story short, your role is to make sure that the community's desires are reflected in moving these projects forward. There's limitations on whether it's legislative or quasi judicial. Legislative is where it's big picture items that impact the whole community, where the quasi judicial would be site specific, where it's going to have an impact to a select number of individuals rather than the community at large. There's limitations on being able to have conversations with people because you're considered there's a term of art for it. What was it? Municipal officers. You're considered municipal officers.
It's just something there.
Byron, do you remember the last time you were in town doing a training for the planning commission?
I never have.
You never have. There was a training we had done, but it was all inclusive with city employees, basically about cell phones and emails.
Mhm.
But I don't think, since I've been with planning commission in 2016, I don't think we've ever had a.
No, and I've been having a larger conversation with the city manager about this. So there's a big program out there. It's called Jurassic Parliament, and they go through a lot of training and policies and procedures with different boards and commissions, staff, city council. And we're thinking about maybe doing something like that we're going to maybe try to get all the boards and commissions in the same room together at some point in the future. And then a lot of the staff liaison as well.
Yeah, we had it in here and it was a great training.
Yeah.
I think it was 2017 or 18 maybe. 17.
Yeah, and a lot of, and we've heard. And we're not the only ones in that boat. What we've heard is, yeah, a lot of commissions would like to have a little bit of update, a little more updates on
Yeah.
common laws, what's changed, where we're moving, where we're heading. What are the desires of council? Like how does just those really simple communication items.
I can't recommend, I mean, it's kind of dry, but short course on local planning that the State Department of Commerce has, and they've got webinars that they'll do live, but there's also recorded ones, or if you just wanted to have it going in the background,
Mhm.
and it goes through the Growth Management Act and the different roles of planning commission, city councils, planning staff. It's beneficial, it's helpful, but I will warn you, maybe do it in the morning when you're drinking. And yeah, MRSC, of course, as well. And I think it's the website you can peruse without anything, but if you have questions, you have to create an account and you have to be verified that you have the ability to access their resources, their staff essentially.
Mhm.
So I've had questions, trying to think of something specific. I can't off the top of my mind, but it was a direct question. One community had a conditional use permit that they issued for a project, but it didn't include a deadline. You don't finish your project in 3 years, it's null and void sort of a thing. So they're asking what the provisions are if there's an expiration period for that permit. So I consulted MRSC and I sent them a message and they email you back directly. Someone from their staff does. And in that instance, the answer is if your code doesn't say there's an expiration period and it's not in your decision, those permits that you issue are good to the end of time.
So, yeah, so oftentimes, and there's actually an ongoing permit like this in the city of Yakima, where somebody they put in an application for a bakery. And the bakery had no termination on the land use decision. So it went off, it reverted to building permits. And building permits they're good for the life of the property, basically. So it's been going on 10 years. And the project's still not done, but they renew the permit or they pull a new one every time it comes up to expire. So.
Raise it up.
Commissioners, do you have any questions? Can you give us more examples of
The communication part.
well,
Well, and there are exceptions, like if you're, it's, not only for planning commission, but city councils too. So if you're, there's things like if you're getting campaign contributions, that's not considered ex parte contact. If you are out and you're at an event or something like that, when you're running for office, you're holding a town hall or something like that, that wouldn't necessarily be ex parte contact. It's where it's specific to certain project where it's like, well, Commissioner Dolan, I'm Byron Gums and I've got this 5 acres of land that I want to put in a big subdivision on, and I've been talking to Trevor and it's not, he's not giving me the answers that I want. And I was, thinking maybe, if I name a road after you, you might be a little bit more inclined to approve my project, or, your family's a bunch of plumbers and maybe we'll hire you to, install the water mains and stuff like that. It's things like that you got to be really careful of. That's where you can get into a lot of trouble.
So, and then, I'm sorry, I didn't want to cut anybody off. Alex. And then kind of when we get into like the nitty gritty of like a staff report and staff findings and commission findings and commission recommendations. And I've been talking to Elizabeth about this, and all of us department heads, we're trying to do a little bit better job on this. And so we can always ask for more. We can always ask for more. We can make a recommendation as long as we have some findings to support it. We can always ask for more, or ask for something to be remanded, or ask for X, Y, and Z from this applicant. So, or we can approve things, recommend things with conditions. So you can say, I like this, and I am inclined to go for this, but I really want to see a wetland study or a traffic impact analysis, or I want to see a density something or another. We can ask for that as we move on to the move a recommendation forward. So there's ways to be creative with things that I'm trying to be a lot more thoughtful with you and with city council. Yeah.
So let's say the planning commission has something come before them. It then has gone to council. Council's tabled it possibly to think about it. Are we able to talk to council members about the project or zoning or whatever it might be, land use?
So if it's a closed record, well, yeah, that kind of treading the line of a legal question. I don't have enough initials after my name. I would say, if it's a personal conversation, it really, I'm leaning more towards, if you're clarifying something, I don't see an issue with that. If council has a question, like, what did you mean by this, or what, I'm reading through the record and this doesn't make sense to me. Can you help me out?
Mhm.
But if it's something where it's outside of the record, or it's kind of a personal opinion on something, I don't think that would be appropriate. With legislative decisions, it's going to be a little bit different because it's your opinions that end up
Mhm.
coming into play. But I'd be wary of some of those conversations where you're trying to sway the decision of council.
So no is best, basically. Yeah.
Err on
Okay.
the side of
Yeah.
caution.
Yeah. I've been in session before with council where someone excused themselves from up here and went behind and acted as a citizen. Is that legal?
As what was the word, municipal officer, you really shouldn't be doing that, because you're in the role as a planning commissioner, and you're supposed to be the citizen guidance for city council.
I think he recused himself from the vote and then went out and spoke as a citizen. That was before you were here, but I didn't know.
I
Dan was the chair then, but I didn't
go like this.
Yeah.
Ooh.
Yeah, well, it was Dave Rand, so
Okay.
didn't know
Yeah.
what to do with that at that point.
Yeah, I mean, that's something where, I'd be curious to hear what legal counsel's response to that would be.
Mhm.
I think that, would,
I did ask that question to our attorney a little bit, and I'd be happy to send out an email, but it sounded like he would advise try not to do that. Yeah, it's not the best, because remember, every decision we make is appealable to somebody.
Mhm.
So, and if there's a due process procedural error, Superior Court loves that. So, yeah.
and what that ends up, they just kick it back and you have to start over.
Yeah.
They remand the decision back.
Yeah, you start from, I'm sorry, go ahead.
So if we go through a process and we come up with recommendations. And then the recommendations aren't quite what the developer wants to see happen. And they pull their permit. And then they override us and go straight to council. Is that
So,
legal?
it depends if you're providing a recommendation for city council to take action on, city council's decision is what matters. So they can ignore everything that you say or do, because it's their decision. You're just making a recommendation to them. So for example, say there's a subdivision where they propose a half-acre park. And you say, no, we want it to be a 1 acre park. And that's what's in your recommendation. City council and their decision can say, no, it's only going to be a half-acre park.
What if the code requires a 1 acre park?
Well, if the code requires a 1 acre park, then that would be in the staff report and stuff. And then if it's really, so city council can, I would advise against it, but they can kind of make their own choices to that. To that extent. I mean, I don't want to name names, but I've basically been blatantly told to ignore certain things. And my role is to advise them of the risk if they choose not to follow those standards, because it really opens you up to a lawsuit where say you do that for one person and you don't do it for the next person, they can appeal and likely win. So they wouldn't have to do the same level of improvement that you're trying to make. Or if the city council's decision is appealed by somebody else that previously had the requirement of the 1 acre, then they'd have to start all over again. So it's really city council's decision, but there are risks associated with not following what your regulations state.
Or,
Anything.
no, the risks are for who?
Oh, the risk
Council.
The risk is for, so it would likely end up where if a decision was made and it was appealed, where they had to start over, then the applicant could sue the city for the time, for the cost of producing all the documents. So it'd be a monetary lawsuit, and then they'd have to go through that process again and be in front of you and be in front of city council.
Well, that's what my question was, that can they actually disregard our if they resubmit their application, wouldn't they have to come before planning commission again, or would they go straight to council?
It would start the process over again. I mean, I guess it depends on, because all of your appeals are judicial appeals, so they go to the superior court system. So it would depend on how the judge says. If the judge says this needs to go back in front of city council or needs to go back in front of planning commission, that I don't know.
And it also, some of that might come from our attorneys as well, and their advice to staff. One of the first ones that I looked at when I got here and I dug into it, I like, what the heck happened to this? There is a, I'm not gonna say exactly where it is, but there is a mobile home court project in Sunnyside that didn't receive all the love and attention that it deserved. And it was approved essentially with the council, just like a direct council decision is essentially. Yeah. So, but council approved it as the application was presented. Council is the final decision-making body, is what I was advised, that they're the final decision-making body, and nobody appealed it during the 21-day LUPA appeal period. And it now exists. So
There was some changes though that were for the better.
yeah, it was, going through it, I was like, oh my goodness.
Couple people moved out of town, but
Yeah.
I don't know if this is appropriate to ask this question now, but we have Byron, what is the status right now with the project?
Which one?
The 396 apartment project.
So that one I was advised by our legal counsel that it going through our code. It meets the status of a conditional use permit, and the conditional use permit is and I was kind of torn between this because it doesn't really, our code has some hangovers. It's not clear in a lot of ways. But it meets the definition of a conditional use permit. And the conditional use permit is supposed to be reviewed by our Board of Adjustment. We don't have a Board of Adjustment.
we took their place.
No, the hearing examiner took their place.
Board of Adjustment, it was explained to me that this commission, the planning commission was put in place. And I forget the dates, but they were put in place because the Board of Adjustments for Sunnyside, they were the ones that took everything and looked at it and sent it to council. And it turned into a kind of a problem.
So the RCWs, as I was going through them, the 35A.63. So 35.63
These are
doesn't require a Board of Adjustment. 35A.63 does for cities over 2,500. And it says that the members of the Board of Adjustment cannot be the Planning Commission.
Oh, okay.
Yeah.
That's why they switched it then.
Yeah.
They eliminated the Board of Adjustment,
Yes.
which is what it was called when I was talking to the gentleman that explained it to me. And he was here when it happened, and then he said, yeah, you guys are taking their place as far as reviewing projects and plans and to give the council a little bit of insight into what's going to take place.
Yeah, so no, it's so then what has supposed to be, and that's something, one of those things again that I look at and I grit my teeth and I try not to say anything. We just try to move forward. And I'm really glad we're having this conversation tonight. So we can all, yeah. But no, the Board of Adjustments is supposed to be a hearing examiner, which is a third party, and that was established under 2.50 something or another. But he's supposed to hear conditional use permits and just a handful of other things, but not too many.
That goes to county though, doesn't it? Or we have a city?
We have it's Gary Coolier, Mr. Gary Coolier. He is the hearing examiner for Yakima County. Is he for Grandview or Granger?
Yeah, Granger, he's Tompanish's city attorney. Boy, I think there's other
He's
jurisdictions out there.
he's pretty well respected in his field. He's been doing it for
Decades.
ever.
So does this does not come before us for a conditional use permit then?
No.
Okay,
Mm-mm.
so is there a date for the examiner on this project?
Yes, it is coming up, actually. It's next week, Wednesday at 9 a.m. right here.
And he'll be doing a review of this project.
He'll be having an open public hearing for it. Yep. Oh, but
And what is the typical what happens after that?
well, he issues a decision within 10 business days. So oftentimes he does not say what he's going to do and he will weigh public testimony, he'll weigh the staff report, he'll weigh the municipal code, and he'll make a decision from there.
And then
What's
it
the
goes
date
to
of that
council after that?
open
Yeah.
meeting?
Wednesday, July 19th at 9 a.m. right here.
I don't think council makes the final decision, I think.
Yeah, you're correct. Yeah, I'm sorry about that. Yeah.
His decision is the final decision.
On the conditional use permit.
And then his decision, I think, is it appealable to council? Or is that directly a Superior Court? Is it Lupa?
Landlord.
Okay, Lupa then. Okay.
That's a problem for conditional use.
Yes.
So his appeal or his then decision would be appealable to Superior Court under Lupa, Land Use Petition Act, which is a 21-day appeal period. And they would file directly with Superior Court.
Says closed record appeal / final decision. Says only if appealed then before council on ordinance adoption. Doesn't make sense. to me. Oh, I'm reading the wrong, I was reading in type 3, not a type 5. I'm sorry.
Oh, well, that makes sense.
Only if appealed before the council. Then. Yeah, so. I guess the first stop, if there was an appeal of that, it would go to the council.
Okay,
And then if the council's decision is appealed, then it goes to Supreme Court.
okay, that's what I thought it was. Okay, so,
And who appeals the council's decision?
It could be any aggrieved party. So usually you have to be a party of record to have a standing to appeal. So the applicant, or if you provide a testimony or provide a written comment, you become a party of record. And those are the only people that can appeal. So if you're on the sidelines and just fly on the wall, you can't come in at the end and appeal any decisions. You need to be a part of the process to be able to appeal. As far as the separation of planning commission and board of adjustment, that's under 35A.63.110. And it says, no member of the board of adjustment shall be a member of the planning agency or the legislative body. So city council or planning commission can't be members of the board of adjustment.
That makes sense.
Do we just not have a board of adjustment because we've not had a need, or what was the,
no, we went to a hearing examiner format.
oh,
That's what we
okay.
did, yeah. Which just keeps things cleaner. It's a third party and then they just do it.
Mhm.
Yeah. And then next month I have comp plan amendments coming to you. So you'll get to review those. I'll send all that stuff out tomorrow. But part of that is a bunch of text amendments, which is a legislative action. And then the city has proposed a comp plan amendment rezone for the Munson site, which will be a quasi judicial action. So there'll be, you'll have both to look at next month.
So notices for the public that are within 300 feet
Mhm.
for next week, did those notices go out yet, or do they get a notice for that?
Yeah, that all went out from the 19th, 30 days before the 19th. So they've
And with those mailings, sorry to interrupt, there's typically an affidavit of mailing by whomever staff member would have done the
Yeah.
mailing, making sure that
Oh, right.
the letters all got the right addresses on them.
So they don't come back and say, I didn't hear about it.
Yeah.
Yeah, and that's here's my signed affidavit of mailing saying that I mailed these out on June 28th, 2023 or something, whatever it is.
Is there anything else about that project that you think we need to go over, or maybe mistakes that was made, or anything that, stands out that could have done better or been better?
I mean, I should have put together a more thorough, probably, and there's all learning lessons for all of us, I suppose. More thorough script. Yeah, there it is. That's the word I'm looking for, script. And then yeah, I think that probably was one of the big things. I probably should have put together a more thorough script guide. And one of the big things I think we need to jump into probably this winter, hopefully, maybe around September, October. But I really think we need to establish some bylaws too, because we're digging around and we only have what Byron presented on tonight was just the establishment of the planning commission. We don't really have any bylaws for code of conduct or, penalties if something happens with a planning commission member. We don't really have anything that establishes it. So we should probably get on that.
I was talking to Elizabeth and she said that there was something in there about, because of Dave Rand, that there was things in there she was going to follow up on too, because of the way he was presenting things at our meeting.
I don't know if that's ever been done, but we should do it. We should do it.
Yeah, we've had, for everything we do, we have to have bylaws. for-
Yeah.
I mean, all the Miss Sunnyside and Miss Cinco de Mayo, and every one of those
A lot
projects.
less important things than this.
Yeah, they all had to have bylaws.
Yes.
And they had come to me and asked me to help them write bylaws for the Miss Cinco de Mayo.
Yeah.
Project and,
I think that's a requirement for nonprofits or 503s.
Yeah.
Yeah.
yeah, and then when you look at the books and there was nothing on all the stubs.
There may be something with an inch of dust on it somewhere, but.
There, yeah.
When I was looking at my records for Sunnyside and when Trevor was looking, I didn't see anything.
Mhm.
Because Mike Shuttleworth was in my position, not my immediate predecessor, but before him. So I've got access to his digital files on things and I know that there's been some work with Sunnyside over the last few years, but there wasn't anything relating to planning commission bylaws or anything like that. It was all project specific.
Yeah, he gave us a lot of paper.
Mm.
Very good at researching, you know, what kind of birds are in this area. And pretty much, he went right down to the plants and the soil types. I read that thing and I was going, wow, getting a headache here.
For some studies, yeah, it's needed.
He was very thorough.
Yeah.
I don't know that it needed to be that thorough, but you know,
If it's comp plan, probably not. If it were a report relating to like a critical areas permit or wetlands
yeah,
report or something like that.
but that would be more the developers
Typically, yes.
going in to see what they're gonna have to do for foundations and.
Yeah, that's where you have your rules and regulations, and it would be up to staff to administer those. And that's where, when somebody were to submit an application, you could say, well, our database shows there's potential wetlands here, so we're going to need this report from a scientist or a specialist with findings saying yes or no.
Yeah, that
You need to make educated decisions.
we did a Holiday Inn up in Union Gap. And they called several of us in to look at it and make a recommendation just off. It was crazy, but they ended up putting about 2.5, 3 feet of riprap in there just to be able to.
Oh, yeah, there's a lot of high groundwater.
Oh, yeah, it's 3 feet and you're in a waiting pool.
Yeah, well, if you go to Costco and all that retaining pond and then stormwater pond, they punch through a confining layer. And they had water flowing out of it, so it didn't even hold stormwater, it was flowing groundwater out.
Artesian, they ended up putting 6-inch pumps in there
I think so, you're
for
right.
quite a while until they could seal it all up.
Yeah, I mean, yeah, so prior to being with YB-COG, I was with Yakima County for about 16 years. I was their environmental and natural resources planner. And I did other work, of course, but my area of expertise was critical areas, shorelines, and SEPA.
We have an artesian here.
Mhm.
Yeah, we're at the airport.
A lot of people don't think of Sunnyside as kind of being in a little valley, but it's the low spot. I remember working with folks that are just on the west side of town where you have a lot of those Russian olives and things like that. And being like, hey, there's high groundwater here. There's a good chance of wetlands. What do you mean? We're in a desert. It's like, yeah, but if you look, you got Snipes Mountain and you got Rattlesnake Mountains and all of these things, and your Sunnyside's in that low spot right there. So it collects all of that water.
Yeah, the infamous railroad story,
That was done many times.
the railroad bed fails or whatever and train goes over.
Yeah, there's a lot of spots here that are like that.
Okay, so if we have questions in the future, we can go to MRSC or Washington State Department of Commerce. And there's video online, training online.
Yes, there are lots of training opportunities.
Okay.
I think one of the things that the state Department of Commerce does really well is recognize that there's always new planning staff, there's always new planning commissioners, there's always new city council. So they have a wide range of training resources to get everybody up to speed so they can be making those educated decisions
Mhm.
and doing what's right by what the laws say.
Okay. Is it typical or normal if someone has a question on the planning commission and they direct it to Trevor, do they copy all the other commissioners, or is that just a direct question to, is there a procedure?
No, it's
Okay.
whatever you want in your bylaws.
Okay.
If
But
you
we
want to
don't
put
have
it in your bylaws, or, I mean,
Mhm.
I don't think there's any sort of issue with any direct questions to Trevor.
Okay.
Yeah. He's kind of your staff, if you will.
Yeah.
Yeah.
right.
So yeah, typically if you want to CC everybody, feel free to CC everybody, or if you just want to directly contact me, directly contact me and I'll try to get you an answer. I'll try to be timely about it.
No, it's.
Some things take a little longer than others, but yeah, because oftentimes planning is highly litigious. It's a highly litigious field. And people sue for a lot of reasons, and they'll find reasons to sue. And you know, I've heard some people describe planners and and lawyers as the same person, but just in different parts of that lower level of where where I'll go maybe when we die.
I've heard the difference between a planner and a lawyer is about $200 an hour.
Yeah. So
Planner makes me.
No.
yeah.
Anyone have any more questions for Byron?
True.
And I'm happy if Trevor sees the need to come back and do things like this, or assist. I know we're going to be helping with some housing stuff in the future here. So Sunnyside is a member of YVCOG, and you can tap us as a resource.
Mhm.
Thank you very much. We appreciate you being here very much.
Thank you, Iron.
Any there's no public comments. Members of the planning commissioners, anything not on the agenda that you'd like to talk about or ask? I did have a question. There's a City of Sunnyside sign out in front of Rand's property on Yakima Valley Highway. What is that one pertaining to?
That's a SEPA. So that's a big mess. So
I figured it
What
was.
a surprise.
that's a big mess. So what happened is there's a ditch that runs through there. That's an old LID line. It's now an MS4 line. It's maintained by the Department of Ecology. What happened is somebody got a wise idea and decided to dump a bunch of sand and some 8-inch corrugated steel pipes in there, and they was just going to make it a flat surface all the way out to the highway and pipe it. No, the answer is no. No, we're not doing that. So,
It's where I'm thinking there was a gentleman out there with a tractor on my way in today.
yes, potentially.
Oh, boy.
So there's ongoing issues with that site right now. It's currently there's a cease and desist order on that site. There's multiple things on that site. It's in it's in the Washington State Department of Commerce right now. It's in their C program. Him and the property next door, they have some issues too. So
I just wondered because it's a similar sign to the one on the property for the project. So I
yeah,
wasn't sure if that was.
no, there's some issues there. There's some code enforcement things that we're trying to correct. And it's been fun. So
Any other additional items from staff?
as I mentioned, comp plan amendments are coming up soon. You'll be seeing those next month. And then the month after that, I think we might have some rezones for you to look at. So that'll be coming up. And then we'll be working on bylaws, and then I have to get your park stuff. So yes, I'll be doing that after that as well.
Then we'll have meetings for June and July and August.
And then I'll have minutes. Yes.
Yes. So August 8th is our next meeting. I've got it on my calendar. I'm free and clear. Everybody else?
At 5:30.
5:30. Yes, I'm gonna, yes, here. Yeah, I'm gonna try to fix this template. So
We get all those W's in there.
Okay, if that's everything, we can adjourn the meeting. It's 46. Thank you, everybody. Thank you, Byron. Really appreciate you being here.
Yeah. Hopefully, I tried to keep it not too